Good afternoon. My name is Ryan Yules, and I'm a partner with the Seacrest Wardle Law Firm in Troy, Michigan. This afternoon, I am going to present you with a webinar on the application of the Recreational Land Use Act in Michigan. You may be asking yourself, what is the Recreational Land Use Act? You may be also asking yourself, how does the Recreational Land Use Act affect me? Well, the Recreational Land Use Act may impact you if you're an owner of land, a tenant, or a lessee of land, or an insurer of an owner, tenant, or lessee of land. Most importantly, the Recreational Land Use Act may provide you with an absolute defense if you are a landowner, tenant, or lessee of land against whom a claim is made. What is the Recreational Land Use Act? In Michigan, the Act is found at MCL 324.73301. At MCL 324.73301 parens 1, the Act states, except as otherwise provided in this section, a cause of action does not arise for injuries to a person who is on the land of another without paying to the owner, tenant, or lessee of the land a valuable consideration for the purpose of fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowmobiling, or any other outdoor recreational use or trail use, with or without permission, against the owner, tenant, or lessee of the land, unless the injuries were caused by the gross negligence or willful and wanton misconduct of the owner, tenant, or lessee. Upon reading of the Act, it appears to be fairly straightforward. However, as you start digging into it, it reveals certain complexities. First, let's look at why the statute was enacted by the legislature. Most people who are private landowners do not want other people on their land for recreational activities. For instance, most homeowners don't want individuals on their private property for recreational use. Landowners like their privacy and want to avoid incidents occurring on their land for which they might become liable. However, Michigan is a state with a lot of open land and land on which many forms of recreational activities take place. The state of Michigan encourages these recreational activities on open land. Thus, the Recreational Land Use Act was enacted to balance the competing interests of landowners and the policy of the state of Michigan to promote recreational activities on its open land. The Recreational Land Use Act creates that balance by establishing immunity from liability for landowners, tenants, and lessees for injuries incurred by persons engaged in recreational land activities on that landowner's, tenant's, or lessee's land. In other words, a landowner is not liable to a person who injures him or herself on the owner's land if that injured person has not paid for the use of the land and the injured person was using the land for a specified recreational land activity. Also, the Recreational Land Use Act does not apply where the landowner, tenant, or lessee was grossly negligent or engaged in willful or wanton misconduct. Thus, the Recreational Land Use Act was put in place to promote the use of private land for recreational purposes while providing an absolute defense and immunity against any claim for injuries suffered by someone who has not paid the landowner, tenant, or lessee to use the land for those recreational activities. The Recreational Land Use Act is a departure from the common law or judge-made law. Under the common law, a landowner owes certain duties of care to persons who enter onto the landowner's land. Those duties, under the common law, are dependent on whether the person using the land is considered an invitee, a licensee, or a trespasser. Under the common law, the greatest duty of care is owed to an invitee. reasonable care must be taken by a landowner to protect an invitee against unreasonable conditions on the land. Under the common law, no duty is owed to an adult who trespasses on land and is unknown to the landowner, except to not engage in willful or wanton misconduct. The Recreational Land Use Act changes the common law. Under the Recreational Land Use Act, all people, including minors, are treated the same. Under the Recreational Land Use Act, all users of land are treated generally as trespassers. A landowner, tenant, or lessee needs only to refrain from gross negligence or willful and wanton misconduct to remain protected by the Recreational Land Use Act. Historically, the Recreational Land Use Act was meant to apply only to large pieces of land that were undeveloped but suitable for outdoor recreational use. The Recreational Land Use Act was not intended to apply to urban, suburban, or subdivided land. This tenet was first set forth in the case of Weimer v. Holmes, which can be found at 429 Mich. 66, and it's a 1987 case. In Weimer, family members were visiting over the Memorial Day weekend at the home of the defendants. There was a man-made pond in the back of the defendant's home. Plaintiff's daughter unfortunately drowned in the pond while the rest of the family was inside the home. Plaintiffs brought suit alleging defendants failed to warn their daughter about a drop-off in the pond, causing her to drown. The Michigan Supreme Court had to apply the Recreational Land Use Act to the facts of the case, and it held that the Recreational Land Use Act did not apply because it was only intended to apply to large tracts of undeveloped land suitable for outdoor recreational land uses. This holding significantly limited the application of the Recreational Land Use Act. This was the law in the state of Michigan for a number of years until the Supreme Court revisited the issue in the case of Neal v. Wilkes. Neal v. Wilkes can be found at 470 Mich. 661, and it's a 2004 case. In Neal, the plaintiff suffered injuries while driving an ATV on defendant's property. The property was an approximate 11-acre lot that was zoned as residential. This land was zoned for residential use only. The injuries were incurred on a part of the property that was maintained by the defendant, meaning that the defendant kept up that part of the property and mowed the lawn regularly. The trial court applied the Weimer's holding to find that the Recreational Land Use Act did not bar the action. Eventually, the Michigan Supreme Court reviewed the case to decide whether the Recreational Land Use Act only applied to large tracts of undeveloped land. In rendering its decision, the Michigan Supreme Court took the plain meaning of the Recreational Land Use Act and said that the Weimer's court got it wrong. The court said that the statute placed no restrictions at all on the size of the piece of land with respect to the applicability of the Recreational Land Use Act or whether the land needed to be developed or not in order for the act to apply. In other words, the type of land and its condition is not a factor in whether the Recreational Land Use Act will apply. This holding reflected a major change in the law between the decision by the Weimer's court and the holding of the Neal court. Essentially, after Neal, all landowners, tenants, and lessees can take advantage of the protection of the Recreational Land Use Act. Put simply, land means land. Land meaning land, basically relative to the Recreational Land Use Act, means that the statute contains no limitation on the type of land involved. The Recreational Land Use Act applies to owners of large tracts of land and small tracts of land, undeveloped land and developed land, vacant land and occupied land, land suitable for outdoor recreational uses, and land not suitable for such uses. urban or suburban land, and rural land and subdivided land. Therefore, the Recreational Land Use Act applies to any type of land. The legislature, as referenced by the Neal Court, specified the types of recreational use to which the Recreational Land Use Act applies. The legislature specified, and the statute states, fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowmobiling are all included in what is defined as outdoor recreational activity. The court explained that when a general term in a statute follows a series of specific terms, the general term is interpreted to include only things of the same kind, class, character, or nature as those specifically enumerated. No court after Neal has gone on to place limits on the types of recreational outdoor activities that would fall within the scope of the statute. So when are you liable as a landowner, tenant, or lessee under the Recreational Land Use Act? When does it apply? In other words, when would a landowner, tenant, or lessee be liable for injuries suffered by a person engaged in outdoor recreational activities on private land? The Recreational Land Use Act does not apply when the injured person paid consideration for use of the land. The statute specifically states that the Recreational Land Use Act does not apply when the landowner, tenant, or lessee has been paid. Where consideration has been received, the landowner, tenant, or lessee may have a claim brought against him or her, and the Recreational Land Use Act will not act to bar the claim. The consideration received, however, must be for the particular outdoor recreational use of the land. The Recreational Land Use Act also does not apply where the landowner, tenant, or lessee acted grossly negligent or with willful or wanton misconduct. What is gross negligence? Gross negligence is defined as conduct by the defendant that is so reckless so as to demonstrate a substantial lack of concern for whether an injury resulted to a plaintiff. What is willful or wanton misconduct? Willful or wanton misconduct is defined as conduct that shows an intent to harm, or, if not that, such indifference to whether harm will result so as to be the equivalent of a willingness that it does. When gross negligence or willful or wanton misconduct are found, the landowner, tenant, or lessee will not be protected by the Recreational Land Use Act. The Recreational Land Use Act does not, however, create an exception to governmental immunity. This is true even when an injury is alleged to have occurred due to gross negligence or willful or wanton misconduct relative to that governmental entity. In fact, in order to be sued, there must be a specific provision of a given statute that creates an exception to said governmental immunity. The Recreational Land Use Act has no such exception. The Recreational Land Use Act bars any type of action, not just actions that sound in premises liability. The Michigan Court of Appeals in 2015 confirmed this in the case of Schubeck v. Kelly, which is an unpublished opinion, but it is persuasive and likely to be followed by other courts in the state of Michigan. The Schubeck case involved a negligence claim, not one for premises liability. The defendants moved for summary disposition in that case based on the Recreational Land Use Act, and the plaintiff countered with an argument that the act only applies to premises liability actions. The Court of Appeals held that the plain language of the Recreational Land Use Act makes clear that it is applicable to any cause of action, and that the legislature could have limited the applicability of the act if it had so wanted to. Thus, defendant's counsel and defense counsel in any action must not ignore application of the Recreational Land Use Act no matter what the label on a plaintiff's claim. In other words, even if the plaintiff's complaint brings a count labeled as a negligence claim. Defense counsel must plead the Recreational Land Use Act as an affirmative defense. As the court in Schoonbeck stated, the Recreational Land Use Act bars any cause of action, not just those sounding in premises liability or labeled premises liability. Let's now talk about the recent developments relative to the Recreational Land Use Act. The first situation that we'll talk about involves a landowner who has only a possessory right in something like a lake on a piece of property. A landowner who has only a possessory right in a lake may take advantage of the Recreational Land Use Act as a defense to any claim. In the case of Warden Pittman v. Pancato, an unpublished opinion of the Michigan Court of Appeals from December of 2016, the Michigan Court of Appeals held that a landowner with possessory rights to a lake may invoke the Recreational Land Use Act even though the landowner did not own the lake where the plaintiff had drowned. Second, the situation might arise where the Recreational Land Use Act would bar recovery to a plaintiff who hit something like a fallen tree branch while sledding or a fallen tree while sledding. The case of Nash v. Duncan Park Commission dealt with this very situation. In that case, an 11-year-old boy was killed when he hit a fallen tree while sledding. The trial court granted defendant's motion for summary disposition based on the Recreational Land Use Act. Thereafter, the plaintiff's estate appealed. The issue before the Court of Appeals was whether the defendant landowner was liable for the death of plaintiff when he struck a naturally fallen tree while sledding down a wooded, natural hill in an undeveloped tract of land. The Court of Appeals, affirming the trial court ruling, held that the case is nothing more than a mere negligence case wherein plaintiff was engaged in an outdoor recreational activity without paying. Thus, the Recreational Land Use Act applied. The third situation we'll talk about is one where the Supreme Court of Michigan was forced to decide whether a certain activity is a, quote, recreational activity, end quote, so as to invoke the Recreational Land Use Act. In the case of Otto v. Inn at Watervale, Inc., found at 501 Mich. 1044, which is a 2018 case, the plaintiff, Otto, was injured when he stepped on hot coals, essentially a fire pit, while walking near a lake on a camping trip. The trial court granted summary disposition, but the Michigan Court of Appeals overturned that ruling, holding that, quote, Bailey was not engaged in an other outdoor recreational use, end quote, as is required by Recreational Land Use Act, and as a result, the act did not apply. The Michigan Supreme Court granted leave to appeal and eventually reversed the Court of Appeals and reinstated the trial court's order granting summary disposition. In particular, the Michigan Supreme Court found that plaintiff's activity, that being beach play, is the same sort of activity as other outdoor recreational use activities listed in the statute. Thus, the Recreational Land Use Act applied to bar the claim. The gist of the Otto case, as decided by the Michigan Supreme Court, is that what qualifies as a recreational outdoor activity has a very broad definition and likely includes many activities not specifically enumerated by the statute. At the end of the day, the question remains as to what will be the impact on landowners. If a person enters your land, for example, and without paying for its use engages in an outdoor recreational activity, you, as the landowner, are not liable. Examples of this might be where someone crosses your land while cross-country skiing, and that person falls and injures him or herself. You, as the landowner in that scenario, are not liable under the Recreational Land Use Act, assuming that the skier did not pay to use your land to cross-country ski, and that you, as the landowner, did not act grossly negligent or with willful or wanton misconduct with regard to that person cross-country skiing. Another example of a landowner not being liable would be where a person is injured while snowmobiling across a landowner's parking lot. You, as the landowner, are not liable under the Recreational Land Use Act, again, assuming that the person snowmobiling across the parking lot did not pay to use the land, and you, as the landowner, did not weren't grossly negligent or act with willful or wanton misconduct with regard to that person's activities. In sum, if the fact pattern suggests that the injured party was injured while quote unquote playing outside, and that person did not pay the landowner, tenant, or lessee to use the land, then the Recreational Land Use Act is very likely to bar any claim, and the Recreational Land Use Act must be pled as a defense in any such claim. This concludes this webinar on the application in the state of Michigan of the Recreational Land Use Act. I hope you found the information informative and useful, and please feel free to contact me at any time with any questions on the application of the Land Use Act as it may apply to any landowner, tenant, or lessee in the state of Michigan. Thank you.